Namaste everybody, I Kumari Akanksha Rai. So today's topic is completely recent one in which Supreme Court contention is very important. So it's related to the clubbing of FIR which is filed against one person at the several part of Indian territory at one place. That is I hope you got it. That is related with the Nupur Sharma. She filed a petition under Article 32 of Indian Constitution into the Supreme Court by saying that kindly club each and every FIRs which have been registered under the Indian territory at different part or in different jurisdiction. But Supreme Court rejected this contention by saying that your words has put entire country on fire, so we are not going to provide you red carpet. This was a contention. This contention was criticized severally. It was debatable. It was, and against this contention, a second petition was filed into Supreme Court by saying that Supreme Court's remark was not into the favor of Indian judicial system or independence of Indian judiciary or whatever. But not including yourself or ourselves into the much debate of this, that whether it was good or bad, we are directly entering into the legal provisions that from where Supreme Court is getting power, High Court is getting power of clubbing of FIRs, whether it is specially mentioned somewhere or not. So when we are when I was researching for this, so it was find out that can Supreme Court hear the petition under Article 32 of Indian Constitution for the clubbing of FIR in different jurisdictions. By finding out, I found a case that is named as Romila Thapa versus Union of India case. In that case, what had happened? In that case, Supreme Court clearly said that no accused can ask for a right to be heard at the stage of investigation. No accused can choose the place of investigation. And I am going to quote the line. It was said that accused can't be permitted to take control of investigation by choosing from where he should be investigated. Later on, in Narendra G. Goyal versus State of Maharashtra case also, the Supreme Court went up to the extent of holding that it is well settled that the accused can't claim for right to be heard at the stage of investigation, and if it would be done so, that it would overturn the entire criminal jurisprudence into a paradox, that is Pandora's box. Both the case was against the plea which was asked by Nupur Sharma's advocate, that is clubbing of FIR. Later on, I found a case named as VK Sharma versus Union of India case. In that case, what had happened? In that case, Supreme Court also rejected the plea of clubbing each and every FIR which was registered against a person at one place. But it granted liberty to the petitioner to approach respective high courts to bring all the cases registered against that person into one court's jurisdiction, into the entire jurisdiction of one high court. It was the liberty given to it. So following this case observation, in state of Punjab versus Rajesh Sayal case, it was accepted by Punjab High Court under section 482 of CRPC, which is the inherent power of High Courts given under it. And it was said that though VK Sharma judgment was such which was giving power or which was giving liberty to be heard at investigation stage, and that was a plea related to the investigation of FIR. But later on, it was also challenged into the Supreme Court, and it was said that VK Sharma's versus Union of India's judgment could not be taken as a precedent as per section Article 142 of Indian Constitution, because it was not up to the proper law. We know that enormous power is given to the Supreme Court as per section Article 142 of Indian Constitution, but it could not be exercised against or contrary to the well settled law. So it was dismissed, and the VK Sharma judgment was overruled in this case also. So as per section 406 CRPC, if you will go through it, you will find that there is a transferring jurisdiction of Supreme Court through this case section also one can approach to the Supreme Court for the clubbing of FIR, but it's also debatable. Sometime what happened, sometimes Supreme Court allow the petition and allow to club the FIRs, sometime it got rejected. In Nupur Sharma case, what was the actual reason? Nupur Sharma case, the actual reason was that because her contention was entirely against the constitutional framework of our country, and apart from it, it leads to the debate, fire, violence into the country. Whatever the reasonability of this case, it was quite different. It's a pendulite matter, it would be decided by the court. But though this was the reason why Nupur Sharma's petition was not taken into consideration, और ये आप inference निकाल सकते हैं सुप्रीम कोर्ट के ऑब्जर्वेशन से, जहां उन्होंने कही है कि आप ऐसी भाषण दें और आपके वजह से पूरा देश ऑन फायर चला जाए और आपको हम रेड कारपेट बिछाकर नहीं दे सकते। तो ये सारे ऑब्जर्वेशन से आप निकाल सकते हैं कि सुप्रीम कोर्ट का मूड क्या रहा होगा उस वक्त इस जजमेंट को, इस ऑब्जर्वेशन को देने के लिए। सो कॉन्क्लूसिवली, constitutionally you have article 32 of Indian Constitution. As per CRPC you are having power as per section 482 CRPC, 406 CRPC, आप Supreme Court, High Courts respectively you can approach for the clubbing of FIR. So this is the little video which I was thinking that clubbing of FIR generally means to coming together of each and every FIRs to join the every FIRs which was registered against a single person into the territory of India. So this is the simple meaning of it, and you can apply for the into the court for the convenience of both the parties into the hearing or the trial of that case. So this is the short video. I hope it would help it out. We'll meet in next video. Thank you so much.